Good morning, all. Hope you all are doing good. Today's topic is on debentures. So, what we are going to see is about the introduction, a basic introduction, types of debentures, conditions to issue secure debentures. We are going to see about debenture trustees, debenture trust deed, debenture redemption reserve, procedure to issue of debentures as per the Companies Act, conversion of debentures, the taxation aspect, and the FEMA aspect. So, we are going to cover a broad overview of the Companies Act, taxation aspect, and the FEMA Act. Debentures. What we all know about debentures is a debt instrument. It is like a loan and it includes debenture stocks, bonds or any other instruments which evidencing a debt, and it even includes a debt with whether constituting a charge on the assets of the company or not. So it is not necessary that it needs to have a charge on the assets of the company. But this term debentures, it was taken from the Latin word debri, which means a loan or borrow. Debentures can be issued to a select group of people or to a public as a large. And debentures, what is the main difference between debentures and shares is debentures are not the owners of the company. They are the third party to the company. Their position is same as the creditors of the company. Whereas shareholders, they are the owners of the company. They have voting rights. Debentures do not have voting rights. So what benefit debenture holders get is they get a fixed rate of interest, whether it is yearly or half yearly. It will be fixed upon the terms of the issue. Shareholders do not get a fixed rate of interest. They get dividend, and dividend varies with profit. If there is profit, you will get dividend. Whereas dividend is a appropriation of profit. Interest is a charge on the profit. So, and the company can also claim interest as an expense in its while filing its income tax return, whereas dividend cannot be claimed as expense. Debentures can also be convertible, fully convertible, partially convertible, optionally and compulsorily convertible. A company is required to redeem the debentures, and these debentures are redeemable. So they can, after a fixed period, they are either converted or redeemed. Redeemed means redeemed into cash. That is, they are given back their cash. Converted means they are converted into equity shares. And even if there is a loss, the company needs to pay interest, whereas that is not the case in case of dividend. Dividend will be paid only if there is profit. As I said, it is a appropriation of profit, and interest is a charge on the profit. If there is any default in repayment of amount or default in the payment of interest, then the tribunal can be approached by the debenture holders or the debenture trustees. So who is a trustee and all we will see in the upcoming slides. And the power to issue debentures it can be exercised by the board on behalf of the company. So types of debentures is broadly divided into four categories on the basis of security, on the basis of redemption, on the basis of mode of conversion, and on the basis of negotiability. On the basis of security, security means a charge, a secured or unsecured. Secured debentures are those who have only charge of the assets of the company. Say for example, if a company defaults in payment of interest or redemption of debentures, then they can claim their amounts back by selling the assets, by taking charge of the assets of the company. Whereas unsecured debentures cannot have a charge on the assets of the company. So I hope this is clear to all. Next one is on the basis of redemption. Redemption means the debentures upon the terms of issue, they will be redeemed. That is, cash will be given back to the debenture holders after a fixed period of time. Irredeemable debentures which cannot be converted, which cannot be redeemed after a fixed period of time. So irredeemable debentures are not allowed as per the Companies Act. As per the Companies Act 2013, no company can issue irredeemable debentures. On the basis of conversion, as I said, after a fixed period of time, upon the terms of issue, it will be converted into equity shares. So it can be optionally. Optionally means at the option of the debenture holders. If the debenture holders wish to convert, they will convert. If they do not wish, then it will be given back to them as cash. And it is compulsorily convertible. Compulsorily convertible means the debenture holders do not have an option. It will be compulsorily converted into equity shares after a fixed period of time. Non-convertible includes those which cannot be converted into equity shares. Partly convertible and fully convertible say a company issues 100 debentures. Then partly convertible means the company shall, before it issue itself, in the terms of issue itself, say that 80% of this will be converted into shares and 20% will be redeemed into cash. So this is partly convertible. And fully convertible means the full 100 debentures are converted into equity shares. The number of equity shares and all will be decided upon the terms of issue. On the basis of negotiability. Negotiability means transferable. So bearer and registered. Whereas a registered debenture can be transferred by delivery and endorsement, a bearer debenture can be transferred by mere delivery. For this, we can take an example of a check. A bearer check, the name won't be written anywhere. So a bearer check can be transferred by mere delivery. If Mr. X is giving the check to Mr. Y, then Mr. Y can be the holder of that check. Same in the case of debentures. The bearer debentures, the name of the debenture holders won't be mentioned. So it can be transferred by mere delivery. Whereas in the case of registered debentures, the name of the debenture holders will be registered. In the register of debenture holders also, his name will be mentioned. So legal deed or a document, a transfer deed needs to be executed to transfer the debentures. It's same like shares. In this, we are going to see the conditions for the issue of secured debentures. Secured debentures, as I said, they will be having a charge on the assets of the company. Secured debentures can be issued only up to 10 years. The date of redemption shall not exceed 10 years. But in certain cases, it has extended up to 30 years. They can issue debentures for a period exceeding 10 years but not exceeding 30 years. So what are those companies? Those companies are basically engaged in infrastructure type of companies, infrastructure projects, infrastructure finance companies, infrastructure debt fund, non-banking financial companies, and a company permitted by the Ministry or a Department of Central Government or Reserve Bank or NHB, that is National Housing Bank, or any other statutory authority, to issue secured debentures for a period exceeding 10 years. As I said, secured debentures have a charge on the assets of the company. So creation of charge is mandatory. The charge can be created on the assets of the company or the holding company or the subsidiary company or the associate company. So as a group they can create the charge. The charge can be created on the group company as a whole. It can be created on any specific movable property or immobile property. If a debenture has been issued by the government company where it has been guarantee is given by the central government or the state government, then such issue need not be secured by the charge of the assets. So this is why, because the government itself is giving the guarantee for those kind of debentures. So the creation of charge is not mandatory. It should not apply. While issuing secured debentures, the company have to appoint a debenture trustee. Who are the debenture trustees will be seeing in the upcoming slides. And like issue of shares itself, the issue of debentures to public also includes issue of prospectus or letter of offer in case of private placement. So before the issue of prospectus or letter of offer itself, debenture trustees need to be appointed. And a debenture trust deed needs to be executed to protect the interest of the debenture holders. This trust deed should be executed within 60 days from the allotment of debentures. We are going to see about debenture trustees. Who are debenture trustees? Debenture trustees basically act as a channel of communication between the debenture holders and the issuer company. They act as a liaison between the issuing company and the debenture holders. They protect the interest of the debenture holders. And as we said, a creation of charge is mandatory or a debenture trust deed is executed. These and all is executed on in names of the debenture trustees on behalf of the debenture holders. They are registered with SEBI. So anyone who wants to become a debenture trustee, they need to get themselves registered with SEBI. They need to file application with SEBI and follow the procedures mentioned in SEBI. To file application itself, 50,000 is required, which is non-refundable, and the initial registration requires 20 lakhs, which is valid for a period of 5 years. And every 3 years they need to be renewal, and renewal includes 9 lakhs payment to be done to the SEBI. So when it is mandatory, a company cannot issue debentures to more than 500 people without appointing a debenture trustee. And the names of those debenture trustees will be mentioned in the letter of offer or the prospectus. And in all the subsequent notices and communications to the debenture holders, their names, debenture trustees' name needs to be mentioned. Before the appointment of those debenture trustees, a written consent needs to be obtained from them that they are eligible to be appointed as debenture trustees and they have not violated any provisions of SEBI. And that written consent, it shall also appear in the letter of offer issued for inviting the subscription of debentures. Now the question raises, who can be appointed as a debenture trustee? So the SEBI has authorized 4 categories of people who can be appointed as debenture trustees. That is a scheduled bank, a public financial institution, an insurance company, or a body corporate. These 4 categories can only apply to be a debenture trustee. Resignation of debenture trustees. If there is any casual vacancy, that is in case of death or any other medical reason or any other reason, there is a casual vacancy, the board may fill that casual vacancy by passing a board resolution. When a vacancy is caused by the resignation of debenture trustee, then a question arises that something fishy is going on in the company. Why the debenture trustee has given his resignation? Then the vacancy should be filled only by obtaining written consent from the majority of the debenture holders. And these debenture trustees, upon their terms of issue, they would be appointed for a specified period of time and they can be removed from their office before the expired office term only if it is approved by 3/4 of the debenture holders. Only if it is approved by the debenture holders holding not less than 3/4 of the value of the debentures outstanding. Persons not eligible to be appointed as debenture trustees. So these debenture trustees can't be the employees of the company or can't have any interest in the company. Like auditors, we have some disqualification of auditors, that the auditors who have hold shares or who have some interest or have any some financial relationship with the company, they cannot be appointed as auditors. So similarly, in the same way, debenture trustees also need to be an independent party to the company. They should act in favor of the debenture holders and not have any undue interest or undue influence over the company. They should not hold beneficially holding shares in the company. So these persons are not eligible. They can't be the promoter, director, or any key manager person or employee or any other officer of the company. When I say company, it includes the holding company, subsidiary company, associate company, that is the whole group company. The beneficiary should not be beneficially entitled to any money or they shouldn't be indebted to the company. And where in this case also if I say the company, it means the group company. They shouldn't have given any guarantee in respect of the principal debts or something. They shouldn't have any pecuniary relationship with the company amounting to 2% or more of its gross turnover or total income or 50 lakhs, whichever is lower, during the immediately preceding financial years or during the current year. So these pecuniary relationship means financial relationship. and they can't be a relative of the promoter, director or key managerial person of the company. And the company also means the group company, holding, subsidiary and associate company. So these persons are not to be appointed as debenture trustees. Basically, they need to be an independent party and they should act in favor of the debenture holders. They have a huge liability also. Next, we are going to see about the duties of the debenture trustees. So, the letter of offer may contain the terms of the issue. The debenture trustee should verify whether the terms are consistent with the terms of the issue. It shouldn't have any inconsistent terms. There shouldn't be any inconsistency in the terms of the issue. And a debenture trustee will be executed, which will be seen in the next coming slides. So the debenture trustees need to satisfy themselves that the terms in the debenture trust deed are in favor of the debenture holders. Anything shouldn't be against the debenture holders' interest. The debenture trustees can call for periodical review of the status of performance of reports from the company. As I said, the debenture holders are not the owners of the company, so they will not be aware of the day-to-day happenings or day-to-day affairs of the company, whereas shareholders know what is happening on the company. So, to protect the interest of the debenture holders, the debenture trustees can call for periodical status of performance reports from the company, that how the company is performing, what is its financial statements, what are the financial parameters. The debenture trustees also have a duty to communicate promptly to the debenture holders in case of any defaults. If the company has done any default or if the company has conducted any breach of trust, they have to communicate promptly to the debenture holders and they have to even communicate what action or steps the debenture trustees have taken in regards of such default against the company. The debenture trustee also have a duty to appoint a nominee director on the board of the company in the event of default. In this default includes default in the creation of charge on the assets of the company, default in redemption of debentures, and default in payment of interest during the two immediately preceding financial years. So if there is any default of any of these three conditions, then they can appoint a nominee director. So they will come to know about the happenings of the company. They should ensure that the company hasn't committed any breach of trust or they are going on in the terms of the issue. The company should not go against the terms of the issue and the debenture trustees will ensure that if they are gone any against, they need to file appeal with the tribunal and take the necessary measures. They will ensure that the creation of charge on the security for the debenture holders it is done promptly and it is correctly implemented by the company. They need to ensure that the assets of the company and the guarantors, if case any guarantors are there, it is sufficient to discharge the interest and the principal amount. And such assets should be free from any other charges. And they can have some charges on that assets also only if it is agreed by the debenture holders. If it is specifically agreed by the debenture holders. Otherwise, it should be free from charge, any charge. The debentures also have two components, that is principal payment and interest payment. So the assets need to satisfy both principal and interest repayment. They can also call for reports on the utilization of funds raised by the issue of debentures. The debenture trustees can check how the company is utilizing the funds raised by the issue of debentures. The debentures trustees can take steps to convey a meeting of the debenture holders. As and when they feel required, it is necessary to convey a meeting, they will take the necessary steps and ensure that a meeting is conveyed. And they will also ensure that the debentures have been converted or redeemed according to the terms of the issue. Liabilities of debenture trustees. These debenture trustees are highly liable. They have a huge liability. Their liability is to such extent that if they fail to exercise due care and they fail to exercise in a manner of prudent manner, they fail to show the degree of care and due diligence, then the debenture holders can get the amount, claim the amount from the debenture trustees. The debenture holders won't go against the company. They need not file a suit against the company. They can file a suit against the debenture trustees if they act in any breach of trust. And their liability is to such extent that if there is a trust deed, which we'll see in the next slide what is a trust deed, and the trust deed, the terms of issue and all other terms will be mentioned. If in those terms there contains any term which exempts the trustee from its liability or indemnifies him against his any liability for breach of trust, where he fails to show the degree of care and due diligence, then those provisions shall be void. So even the trust deed cannot exempt the debenture trustee from its liabilities. They are held liable for debenture holders, for the interest of the debenture holders. Only on one case their liability can be reduced. It is when they have some exemptions from the liabilities when it is agreed by the majority of debenture holders holding not less than 3/4 of the value of the debentures, and it should be agreed upon at a meeting, at a debenture holders meeting. So if a company fails to redeem the amount or fails to pay the interest, or the debenture trustees come to know that the assets of the company are insufficient or likely to become insufficient, they need to exercise due degree of care and they need to exercise due diligence and take necessary steps and file a petition against the tribunal. If they don't do this, then they can be held liable for the debenture holders. So if they exercise, they may file a petition against before the tribunal, and the tribunal may pass an order which is in favor of the debenture holders. After hearing upon both the parties, he may impose an order. He may order the company to pay the debenture interest and principal amount immediately, or he may impose some restrictions on the incurring of any further liabilities by the company. The tribunal may order what he feels necessary, which is in the favor of the debenture holders. So to such extent, the debenture trustees are liable. So greater is the risk, greater is the reward. So they get hugely paid by the company. And in the same way, they have to pay a huge amount, as I said earlier, for a registration with SEBI. Meeting of debenture holders. I hope these points are clear with you all regarding the liability of the debenture trustees. Meeting of debenture holders. The debenture trustees can convene a meeting of debenture holders as and when he feels necessary, that there is happening of any event which constitutes a breach or default and it affects the interest of the debenture holders, then the debenture trustee may hold a meeting immediately. Or he shall also convey a meeting on a on the debenture holders when he has received a requisition in writing signed by debenture holders holding at least 1/10 in the value of the debentures. So in these two cases, meeting will be convened. What is a debenture trustee? Debenture trustee is a written agreement between the debenture trustees on behalf of the debenture holders and the issuing company. As I said, debenture trustees act as a channel of communication between the debenture holders and the issuing company. So the debenture trustee is executed in favor of the debenture trustees on behalf of the debenture holders. As editing and oral cannot be relied upon, so a written agreement is necessary. So it is mandatory when a company wants to issue debentures to more than 500 members, then the company has to execute a debenture trust deed. And in these debenture trust deed only, the debenture trustees are formally appointed. They cannot be orally appointed. No, formally appointed written agreement is necessary. This is a written agreement, debenture trust deed. It is a written instrument legally conveying property to a trustee, often for the purpose of securing a loan or mortgage. It is a document creating and setting out the terms of the trust. So the terms of the issue and the creation of charge also, it will be formally mentioned in the debenture trust deed. It will contain the name of the trustees, the identity of the beneficiaries, the nature of the trust property, the powers and duties of the trustees, and the interest of the debenture holders. So the companies have, the ROC has prescribed a particular form for this, form SH12, and the debenture trustee needs to be executed as near to possible. These are the words used to, as near there to possible with the form SH12. So it is not mandatory that every company needs to issue it, needs to execute a trust deed in form SH12. It should be as near to possible. A trust deed, like we all know, every document, every legal document of the company can be kept open for issue, kept open for inspection by the members of the company. So similarly, in the case of debenture trust deed, it can be open for issue, open for inspection to any member or debenture holder of the company in the same manner, to the same extent, on the payment of certain fees, as if it was a register of members or the minutes of the meeting or any other legal document. And even a copy can be requested by the member or a debenture holder. It shall be issued to them within 7 days, within 7 working days, on payment of the specified fees. These fees will be mentioned in the articles of association. So what are the contents to be included in a debenture trust deed? The description of the debenture issue, that is the terms of the issue, the details of charge created, the particulars of the appointment of debenture trustees. The debenture trustees are formally appointed here. Event of default. If the company has committed any default in the preceding years, it will be mentioned here. The obligations, liabilities of the company, the meeting of the debenture holders, and the redress of the grievance of debenture holders will be contained in the debenture trust deed. So what is debenture redemption reserve? We all know it is an appropriation of profit. The profits which are available for the payment of dividend, it will be kept aside to a separate reserve called as debenture redemption reserve, and it shall not be utilized by the company except for the purpose of redemption of debentures. So debenture redemption reserve is created. It should be 10% of the value of the outstanding debenture. It is a form of like security for the debenture holders. So which are the companies who are required to create this debenture redemption reserve? Are only the unlisted companies are required. That too, unlisted NBFCs and HFCs. It is non-banking financial corporations and housing finance companies. They are not required to create this debenture redemption reserve. Only the unlisted companies are required to create, and it is 10%. Next is about debenture redemption fund. That is, it is an investment. So many people get confused between DRR and DRF. That is debenture redemption reserve and debenture redemption fund. Where debenture redemption reserve, it is a liabilities. It falls on the balance sheet. We are setting aside our profits. Debenture redemption investment or fund, it is an investment made by the company in some investments which have been permitted by the Companies Act, specified by the Companies Act. So every year the company needs to invest. So invest, it is an asset of the company, and we will also get interest on out of it. Yearly interest, some percentage will be getting out of it. The investment should be made in any one of the following ways. The Companies Act has prescribed 4 methods. It should be deposits with any scheduled bank free of charge, unencumbered securities of the central government or the state government. Unencumbered means free of charge, and unencumbered securities mentioned in the Indian Trust Act and unencumbered bonds of the Indian Trust Act. So the company has mandatory invest in debenture redemption fund in any of these 4 methods, any of these 4 ways. So which are the companies who are mandatorily required to invest is every listed companies, including listed NBFCs and HFCs, housing finance companies, and other unlisted companies, excluding NBFCs and housing financing companies. So difference we saw here is debenture redemption reserve, it needs to be created only by unlisted companies, whereas debenture redemption fund, it should be done by the unlisted companies plus all listed companies. And in unlisted, we are excluding NBFCs and HFCs. So these companies shall on or before 30th April of every year, in respect of debentures issued by the company, invest a sum which shall not be less than 15% of the amount of debentures maturing during the year, ending on the 31st March of the next year in any one of the four methods. So if we are in the month of January, so before this 30th April 2023, we have to deposit 15% of the amount of debentures maturing next year, that is next 31st March 2024. So for financial year 23-24, we have to invest on 30th April 2023 for the 15% of the amount of debentures maturing during the next year, that is 31st March 2024. So I hope this session was useful for all, and I know remaining part is left which will be continued in the upcoming sessions. Thank you all.